Even
Okay,
just
well,
click on not actually golden and expand her. Yeah, there is an option to
expand.
do that. There.
Oh my, now
At
I
least
need
at the
it.
Expand.
very least. There you go.
Then how do I
Just
shut off
choose
my
that.
face? Okay.
Okay? I will leave
Okay.
now.
Okay.
Okay.
I'm gonna just
Okay.
go put you guys in a quiet place, and then I'm just gonna hide. Is that okay? I'm just gonna put you in a quiet
Yeah,
spot,
I mean,
and
God
I'm gonna
bless
go
you.
put my
Yeah.
kids down for a nap because that's what I was gonna do and listen. So
God bless you. But I feel like people see me really big, but not actually golden really small. Or is that just my view?
how do I do?
It's wonderful.
Both.
Oh, when I was on live for
Oh,
like
who's
two
talking?
seconds, there was a layout thing at the bottom, but I can't remember where it was now. It had like different little boxes, and you could pick how you wanted the boxes to look. I wish I could do it from my place, but I can't.
Well, expand both.
Oh, there you
Oh,
go. You did it.
done. You did it. You did it.
You guys are
Well,
equal,
and now,
then
Katie,
I
you
will.
can just.
I will be. You do your thing. You guys enjoy. I'll put you on a charger, and I'll be back to watch later.
Thank you, Katie. You and Bocce are the heroes.
Woo, we're here.
You guys, we have. You can't be good at everything. You know, you really can't.
I do not
Okay,
claim to be
they
good
can't
at
see
this.
us. They're saying, "Hold on."
They can't see us. Oh, there's so many boxes. I wonder why there's so many boxes. Well, we lost Katie. Katie's our host. Although, I mean, I think it's too risky to try and start it over.
I know, right? Okay, it's fixed. Now it's fine. Okay,
Okay.
you can see both me and little girl. You can see both people.
And we're both wearing green.
I know. Yay. Okay.
Hi.
Hi. Hi. I love it when they file something late because I wake
Oh
up in
my
the morning
God.
and you've already done a video on it. So I'm like,
Well,
oh, sweet.
usually it's the other way around because East Coast gets the filings before I even wake up. And so usually I'm like, okay, what's been filed?
Right.
But thanks to the West Coast lawyers here, they're filing at midnight.
I'll tell you what, man. I woke up and I was like, I'm gonna have a really casual day. Like the boys are
Yeah.
at baseball. I'm just gonna hang out. And then I opened up the app and I was like, oh my good God.
Yeah, I was like, if I don't do this video now, like I'm not gonna do it tomorrow until late, and people were already texting me, so I made a mistake, so I tried to correct it in the captions. Uh, Um, to anyone watching, I said June 2024, I meant January 2024 with respect to the calculation, the 300 days for the EEOC administrative complaint. So just FYI, that was a mistake. I was delirious. So sorry.
I just saw someone say, why would you stay up till midnight to file something? People do it all the time
All
because
the
you want it
time.
out for the weekend. Because of this. They want
Yeah.
us to see it. They want us to pick it up. Hi to all the South African people. That is like really
Yeah.
high on my bucket list. How about you? I really
Me
want to go.
too. I want to go. Invite us.
Yes, invite us, please. Tell us where we should go. It's just a
Tell
really
us.
long flight.
It's a
So,
long flight, especially for me.
well, I guess it would depend on which direction you go, right?
Yeah, I don't
you would.
know. Miami. I guess I'd have to go through Miami, actually.
Yeah, I guess you would. Yeah, we already had Van Zandt stuff this week, and it's a big week.
It's a
I
big
did
week.
not. I did not see this coming. Did you?
I actually did not think they were going to file an MJP. I had like a spidey sense something big was going to drop. And I thought maybe the Van Zandt stuff was that big stuff. And I did not expect them to file their MJOP now. It kind of makes sense in retrospect, like the stuff leading up to now, why they would do it. And some people noted that it's like the anniversary of the Van Zandt lawsuit or something. And so there's
No.
some kind of, I don't know if they planned for that. I feel like lawyers are kind of not like that, but maybe they did.
No. I think, and someone just asked, and that's important. I want to make sure we said that this has nothing to do with Van Zandt. This is a
Yeah.
motion that could have been filed from like 2 weeks into the case, anytime up until yesterday,
Yeah.
which is why I think we're all kind of like, why now? Because this is something that can be filed pretty much until you get close to trial. Although once you get to summary judgment, you probably wouldn't do it. But it seems like the operative time is that discovery is about to close. Yeah,
So September 30th, right?
I think
Like
so.
3 days.
And it appears from the motion that was filed last night, they have 2 depositions that day,
Yeah.
because they had the one guy they're fighting about, and then they had the other one that they were arguing about the other day. One was her manager or something.
Yeah, the manager and then the Sony executive. Was it a Sony executive?
I think
The
so.
other one?
I
Yeah,
think so.
that's like the first time I'm seeing Sony appear, and I am like, that's what my current Roman Empire is Sony.
Well, I mean, have you ever? I was talking to Risky Business. Have you ever seen a plaintiff in a case say that even though somebody else noticed the deposition, that they should get to go first because they're the plaintiff? I've never seen
No,
that before.
no, not at all. That seems very odd to me. Like they want to, if you wanted to call them, you should have called them as the witness. You didn't notice the deposition, so why do you get to go first? It doesn't make any sense.
Right? It's they're trying to couch it as we're worried they're going to run out of time, but it's like, yeah, that's just sort of this is the game. I mean, this is
That's
how
the
it
game.
works. Yeah.
Yeah. And you've had
Um,
all this time to depose. You could have deposed them months ago if you wanted to
right.
and run the time then, you know?
Right.
What do you think the judge is going to do about that one?
About the deposition thing.
Yeah.
I think he might say, you can start it at 8 a.m., but I'm not going to tell people how long they can take. Like,
Yeah.
you kids need to work it out amongst yourselves
Yeah.
about how you're going to deal with the 7 hours, because that is the same situation in every single. What does this guy have to say that's so important?
I know. I want to know.
Precious. Little.
My precious.
I know. What could it be? For those of you who are just joining, by the way, Katie's putting her kids down for a nap. She left us in the other room.
She has graciously hosted us because we might be good at a couple of things, but we're not good at TikTok lives.
No, we can't. We all have our things. You did such a good job last night of explaining like what this kind of motion is. I'm sure there are people who haven't made it through all of our videos.
Yeah.
Did you explain like procedurally what it is?
Yeah, so an MJOP, it's confusing. It confuses lawyers, so don't feel bad if you feel confused about it. Even after we explain it, if you feel confused, know that there are lawyers that feel the same way. So an MJOP is exactly like a motion to dismiss, but the timing of it differs from a motion to dismiss. So a motion to dismiss has to be filed in lieu of an answer. So let's say you're sued and you want to respond with an answer. You either file an answer or you file a motion to dismiss, saying there's no validity to these claims. These claims all need to go away. But that time frame between when a complaint is filed and when you file a motion to dismiss is very limited. It's like weeks. And so sometimes you can't get your claims together to file your arguments together to get your motion to dismiss on file, and you lose the opportunity to file a motion to dismiss if you fail to do it before the answer is due. So in this case, there's various strategic reasons why you might want to wait to get all of your arguments together. And there's another added benefit to waiting to file an MJOP, and that is once the amendments deadline passes and the parties can't amend their claims anymore, they're set in stone. And so during the time where you're answering, the other side could be like, actually a second amended complaint, actually a third amended complaint, actually a fourth amended complaint. And you can actually, I've litigated cases where it was the 6th amended complaint. So that is a thing. And so here they waited, it happens. And so here they waited for the amendment deadline to pass, and they, gathered their arguments together. And this is the opportunity that now there's various strategic reasons why they did it now versus earlier, in the middle of discovery, at the beginning of discovery. We can go into that, but they are allowed to file it even up until right before trial, to say there's no legal basis for these claims. Look at the pleading, and these are the claims. They can't hold them up.
Yeah, and the one time that I have I think it's only one time I've ever been successful with one of these. It was when it was a claim about a contract, and the complaint did not attach the contract, but I attached the contract to the answer. And once the contract was in play, because the court could consider both along with attachments, it was clear that the plaintiff had no case. So, you know, instead of having to wait for summary judgment, if you have sort of a, it's pretty funny. I've got a bar and you have books. It's later in the day at my house than it is.
To be fair, it's after 12.
It is after 12. But I think what's interesting about this to me is that, and this is what people have asked. I don't know if you've looked at the comments on your video from last night. A lot of people were asking me this morning, like, why didn't they do this earlier in the case? That's the big question, right?
Yeah.
Because these are essentially motion to dismiss arguments. And there's Katie. Hi, Katie.
Hi, Katie.
I have the theory. I mean, I think it's because they wanted to get all the information so that, you know, if these do get pushed out and these claims are forever barred, that it Lively wouldn't be able to come back and be like, well, yeah, now we'll never see the evidence and we'll never know. I don't know. What do you think?
Yeah, I think there might be a tie-in with the appellate lawyers that came in. I think there might be an appeals angle here because if they were to file this now and put all of their motion to dismiss type arguments legal, like really just purely legal arguments now, and let's say they don't win on them, that's really ripe for an appeal. Because then the appellate lawyers can go and be like, this was not handled correctly. And so that's why I think they did it, so that the issues are preserved for later on in the outcome. That's why I think and the reason why I think they waited may have been more strategic in the sense that like they were allowing discovery to go forward, and I'm curious what your thoughts are on this, but allowing for discovery to go forward so that nobody can say, look, she didn't have an opportunity to go discover all the bad things that they did.
Right.
And now they can't say that because they did. They've had almost the full discovery time, like minus 3 days, to get all of the discovery that they needed. No one can say they didn't have the opportunity. Now, some people are going to go harp on the signal chat and whatever, but like for the most part, thousands upon thousands and hundreds of pages have been transferred between the parties, including deposition transcript.
Apparently, this live is restricted because we're not eligible to be in any search results or et cetera, because it's not somebody reported the live. So interesting.
Oh.
Reported the live? That's mean.
Okay. Report away. We're going to be restricted from doing lives or something?
It's just search results. It just looks like we can still be live, but if people are searching, it looks like it may be tough. They may have to just go to individual pages. So
Okay.
I appealed it. We'll see what happens. I'll send you a screenshot.
Got it. I'm with you. I mean, I'm remembering way back. You guys might remember we had like the very first hearing in this case. We had that like telephone hearing that Lyman let us listen to about when they were trying to get a gag order and all of that. And Friedman was like, we want Blake's deposition. We want Blake's deposition. And you know, they ended up having to wait quite a while. I think it has always been their intent to get her under oath and get that deposition taken, because once you have somebody under oath, that exists forever. You can use that in any proceeding ever for the history of time, right? That is sworn testimony. And so once they've got that and now they have it, they can always hold that up, right? So that if there's ever a claim of, well, this didn't happen or I didn't say that, they can sort of wave that around. So I think they were frustrated that they had to wait so long to get it. But I think that was a big part of the reason why they were like, let's just keep going.
Yeah, they have that deposition transcript forever. And, you know, they probably made a calculated decision that there is a really good chance the judge won't get rid of everything, right? I didn't go through last night my videos. I don't know if you had a chance to yet, but I didn't go through my predictions of which ones are going to prevail and which ones aren't. But there is a very high chance that there will be a claim or two that goes to trial. And so if you get to a trial, you want to make sure you have all that evidence and discovery to best defend yourself at trial. And so that's another reason why they would have gone through the discovery process, because they're like, we're going to have to defend something most likely. And you can never predict how a judge is going to rule on anything, despite what anyone tells you. And so they're like, we are best prepared if we have all the evidence in preparation for trial.
Yeah, I agree. And this is what people often do at summary judgment, which they're doing a little early, which is trying to sort of narrow the claims down and say, what are the things that we're actually going to have to go all the way on? Because if, for example, and I agree, I think it's unlikely that this thing just gets totally granted, although it's possible. They're not bad arguments.
Yeah.
And Lively's left only with a bunch of breach of contract claims. Is she really going to go to trial on breach of contract claims? Or is she going to, stick her hand out and say, maybe we ought to resolve this? Now, what it would take to resolve it, I don't know. But there was one thing, if you don't mind, I was looking at before we got on. Speaking of contracts, this fascinating issue that you guys have been wise to this since Go, which is what's the deal with her contract, right? Exactly. Which contract did she ever sign it? We don't think so. Ellen Garofalo put in a declaration yesterday that there is no one seems to have a signed version of the contract. So, but the point that they've brought up that I think is really interesting is who's the party to the contract that loaned her out as an actor to this production. So we know that Blakel Inc. is the entity that she's created that loans her out, right? Mm-hmm. So that was one side of the contract. And then It Ends With Us LLC, It Ends With Us Movie LLC was the other party. So the employment agreement, and I went and looked at the rider to the employment agreement, and that's true. The parties to that are Blakel Inc. and It Ends With Us Movie LLC. And what they've made here is kind of a domino argument, I think, that they point out, and I'm looking at it right now, and they're absolutely right, that when Blake filed her CRD and got her right to sue letter, she didn't include It Ends With Us Movie LLC as a respondent in the CRD, which means her right to sue letter didn't include It Ends With Us Movie LLC, which means she didn't have the right to sue It Ends With Us LLC in court. And now the statute of limitations has passed. So that's the argument they make. But I think what they're not saying is, if the court says, I agree with you, It Ends With Us LLC is out of the case because you didn't go through the proper process and now the time has passed, I think they would then make the argument to say, well, without It Ends With Us LLC here, how is she suing all these other parties for employment claims when they didn't employ her?
Exactly.
Wayfarer didn't employ her. Steve Sarowitz didn't employ her. Jamie Heath didn't employ, right? So that's my take. I don't know what you think, but it seems to me they're trying to pull the little thread. And then if they can get that, they can pull almost all of the, if not all of the discrimination claims down.
Yeah, I agree. And maybe that's why they didn't hit hard on the timely filing against the other parties, because they're like, well, this is something that we can take at summary judgment, because the key is there's a professional, they call it a professional relationship between Blakel Inc. and It Ends With Us LLC. And if you break that link, then there's arguments that they didn't make here, but there's arguments that this is not a joint employer and that you don't have any claims against Wayfarer, blah, 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 blah. And so they probably needed to rely on extrinsic evidence to make those arguments. And that's why they didn't do them here. I think that's spot on.
I agree. And, a long time ago, I've got a video somewhere about alter ego and about and someone just asked a question about identity of interest. You create these companies for the purposes of exactly this, right? That she creates Blakel Inc. so that if there's ever an issue with her, no one's going to go after her personal assets. And I'm assuming Wayfarer created It Ends With Us Movie LLC for exactly the same reason. So you do this to shield yourself from liability. So they're now basically saying the only two parties in an employment relationship were Blakel and this company that she didn't include anywhere.
Yeah.
I'm fascinated by it. And I'm looking at it and I'm looking at the CRD and it's so weird because they've got Justin, Jamie, Steve, Wayfarer, Melissa, Tag, Jennifer Abel, RWA Communications. Who was that even?
Yeah, I don't even know.
I missed that one.
RWA is Jen Abel. It's her company.
owns her
Oh,
company.
thanks, Katie. See, this is
Okay,
why we
thank
need
you.
you.
Yeah, seriously. And Jed and Street Relations. Maybe they didn't know It Ends With Us LLC existed. No, but they did because they saw the damn rider, didn't they?
And they didn't sign it. Yeah, it's so messy because when I think about it, if they tried to go down this path that it was a professional relationship, it challenges their California FIHA claims. So they didn't want to go that route. They didn't want to go too hard to say like it was a professional relationship. So they tried to argue both sides and see if they could kind of stick, like being in the middle vaguely. Because if you look at the allegations in the complaint, and actually, they did a good job elucidating that in this motion, they don't actually come out and say. I mean, there's like one sentence in her second amended complaint that's like, she was employed by the Wayfarer parties at all.
Yeah,
Like,
you're right.
what? No, she wasn't.
He was
Like,
not.
technically, she was not. And so I think they were trying to like play that allegation vaguely so that they could piece it apart in the way that it would be most beneficial to them when they have to argue it.
Yeah, that's a great point. She just kind of says it like generally, but then when you look at the rider, so the rider is basically an addendum, and when you write an addendum on a contract, the addendum is between the same parties that the contract was between, right? Because only the people who made an agreement can addend it. Only the people who made an agreement can change it. And while we haven't seen the employment agreement, we do have the rider because it's attached. And the rider is attached, is between, and is signed by It Ends With Us Movie LLC and Blakel Inc.
Mm-hmm.
I don't know, I mean, you're a California lawyer and you know FIHA better than I do. Will it try to pull Wayfarer in and say, well, It Ends With Us Movie LLC is solely owned and operated by Wayfarer, ergo that brings Wayfarer in too?
That's the joint employer argument that hypothetically they both operated as an employer to her. But it gets confusing when you have a contractual professional relationship, an independent contractor, essentially, relationship that undoes the presumption that you're employed. So you're either an employee or you're an independent contractor. And that's where it gets messy is like, well, is there a professional relationship with this LLC? Because then you're an independent contractor. You're not quite an employer. And the other one isn't your employer because you know that it's not your employer. And so it begs the question. And that's what I always thought from the beginning was a problem for her, is that she doesn't quite fit into either of the buckets in the way that's helpful to her.
Yeah, that's a really good point. I mean, sometimes in employment cases that I know we both deal with, sometimes it's really obvious who's the employee and who's the employer, and it's all very straightforward. And sometimes it's not.
Yeah, sometimes it's
Sometimes
not.
it's like they worked part time one time as a person for right, and then you have to figure out where these laws apply. I
Yeah.
wonder if does California have a like a website with all of the corporations registered?
Yes, the California Secretary of State's website. So if you just Google California
Okay.
State Secretary of State,
See if It Ends With Us LLC is on there.
it should be. And there's a business search sublink.
Okay.
It is there.
The question, oh, say a lot of people are asking when will the judge rule? Lively gets to respond, right?
Yeah,
So,
she does. Yeah.
and then am I right that in this court you get a response and then they also get a reply?
Yeah, there's a reply. Yeah.
Yeah.
So I
So,
don't know what their deadline is. I think it's a pretty quick turnaround. Usually replies are like, you have 5 days. So they'll
right.
oppose and within 2 weeks ish, probably. And then Wayfarer has to reply to that in like 5 days. And then the judge rules. Well, the judge considers it. I think he will rule on it re relatively expeditiously. Like he might go through the discovery stuff first because that's closing and he needs to resolve the discovery related disputes before that deadline passes. But this is one that I could imagine will get an order in a month's time, for example.
I agree. I mean, I think if the judge is not going to want to read and deal with a bunch of summary judgment motions until he's figured out what he's going to do with,
Exactly. Because
right?
isn't that November something the deadline to file dispositive motions?
It is.
I can't remember. I can't ever find the scheduling order because it's been amended. I'm like, can we just have like, I wish they could pin it on the docket. Like, here's the updated
Right.
deadline.
Or, and the second amended complaint, the scheduling order. I know always have a tab open with the second amended complaint on it.
Yeah.
Okay, so It Ends With Us Movie LLC is an active limited liability company in California. It was created in 2022. I can't get like who the members of it are without signing into this website.
Yeah.
But it says that it's got a principal address somewhere like on Rodeo Drive or something. But I'm sure we could find it because it might depend. Like if the only member of It Ends With Us LLC is Wayfarer, then maybe she could try to pierce through there. I don't know.
But even still, she either argues I'm an employee of It Ends With Us LLC, or I had a professional contractual relationship with It Ends With Us LLC. You can't have both, right?
Right. Yeah, you can't.
So
That's
either
the
you're Blakel Inc. that Blakel Inc. loaned you out to It Ends With Us LLC / Wayfarer, or you were not Blakel Inc. You were just Blake Lively and you worked as an employee for Wayfarer,
that's a
aka It Ends With Us. That's the choice that she has to make.
That's a great point. Yeah, I had a client, this was maybe like 5 or 6 years ago, get audited by the Department of Labor because there were actually a handful of people who were being categorized okay, you got it, risky business. The managing, okay, it's the corporation. Okay. Um, that company, that client, they had a handful of people who were both full-time employees and also independent contractors because they were doing like their full-time job and then they would like come in on the weekends with their catering company
Side
and
gig.
help out the and the Department of Labor came in and ripped them a new one and was like, you cannot
Yeah.
do that because you have to be one or the other.
Yeah. It's a very important distinction, and California has recently did a lot to amend that legislation. Like I think it was, what year was it? I think it was 2019. I think it was 2019 that AB 5 passed in California, which was, if you maybe heard about it, but there was this big hullabaloo about Uber and whether or not the drivers of Uber were considered independent contractors or employees of Uber. And so AB 5 passed and applied this test. It's like a really rigorous test to determine whether or not you're an employer or not. And the laws are really nuanced about it. Like if you're an independent contractor, you don't have certain employee protections in California. You might have it under federal law, but you might not have it in California law. And so this question about whether or not you're an employee is actually a very, very important one to determining your rights, honestly.
People are asking a lot of questions about that since you're California. Will you explain like what it would look like differently for the case for her if she was one versus the other?
Yeah, so she's an independent contractor. She can still bring sexual harassment claims because independent contractors have recently been like folded into that law. It's actually a pretty recent development. So independent contractors have protections under FIHA for harassment, basically sexual harassment, but she loses that protection under federal law. So Title 7, right?
Right.
So it doesn't so if you were to like, and one day I will do this, but if you were to put like the protections that she has under California and the protections she has under federal law, they don't line up. Like she wins in federal in some things and she loses in California on other things, and it's not exactly like because it works in California it works in federal law. It's kind of mismatched.
Yeah, since I don't practice in California, I've dealt with some other states, but yeah, in federal, if you're an independent contractor, you're kind of out of luck
Yeah.
because an employer doesn't have any obligations to you if you're not their employee.
I think
Um,
I was trying to remember, how did they categorize her? How did they talk about her employment in this order or in this motion? They kind of say that she was employed.
Well, they're citing her second amended complaint, right?
Right. So they're saying, I guess they're suggesting that if she's alleging that she was employed, not necessarily like acquiescing to that argument. Because I was thinking about that while I was reading, and I was like, are they saying she was employed? Because that's an argument I would preserve.
Yeah, they say it ends with Us Movie and Lively through her company Blake Link entered into an actor's loan out agreement, and then they just
There
go.
you go. Yeah.
Um,
So they're leaving that open for summary judgment to parse through, I think.
yeah. For those of you who are asking or may have just jumped on, the deadline that's later today is nothing to do with this motion. The deadline for response from Wayfarer later today is on a deposition request that Blake Lively has asked for a deposition coming up on, the 30th, about the timing and the order in which questions are asked. So the motion is a full-blown motion, which means the judge doesn't do anything until Lively responds.
Yeah. I see some questions about what is exhausting administrative remedies. That's so it's just a kind of a fancy way of saying you need to follow this procedural step first. So the laws will have there's administrations like the EEOC and the CRD. They're administrations that are tasked with dealing with complaints that people have under these laws. And the laws require you to go to them first before you go file a lawsuit. It's just kind of like a not a it's just kind of like a bottleneck, I guess is the best way to describe it. Is like if you have an issue of or you have a claim that you've been discriminated against, let the California Civil Rights Department address it first, and then once you have addressed it through them and you have the right to sue, then you can go and file a lawsuit. And there's lots of timings and procedural rules around that to try and help with narrowing down the types of claims that get filed in court. It's an efficiency thing. So you can't just like one day decide to file a discrimination lawsuit. You have to go through those steps.
Yeah, I'm trying to get Frank to turn around. I'm buttering.
Frank!
It's Frank.
Should we show our dogs? Mine's here too.
Oh yeah. Do you want to see everybody? He's looking at me like, lady, what's wrong with you? Okay, come here. Come here. Frankie, look.
Say hi.
Look.
Dogs.
Look, it's doggies. Frankie, do you see the dog?
They're both like, what's happening? Why are you doing this to me?
Yeah. Yeah.
Katie's dog.
I know. Oh, go, baby. I'm one of those people who thinks that dogs should be allowed to be like in the store, in the office.
Agreed. Everywhere.
Well, you're in California. You probably get it more often.
We're pretty dog friendly out here.
Yeah. I think that the takeaway or one of the big picture things for me is that Wayfarer is confident enough to file this at this point, thinking they wouldn't file this if they thought it had no chance. It doesn't mean it's going to be a total win for them, but I don't think they would take this shot if they didn't think that some of this stuff was good, because they can't, that would not be good for their PR strategy.
Yeah. Yeah, I agree. I actually like if anyone comes and says that this is a PR motion, there is no part of this to me is PR. Like this is the most legal thing that we've seen filed pretty much to date, like pure legal arguments. And they do, I think they reference a little piece of extrinsic evidence, I think, which they also redacted. So even that part, even that they did, it wasn't like they were trying to bring something in front of the public to see. It was a pure like there is no legal basis for these claims. I don't think this is PR. This is their legal strategy to narrow this case now that discovery is completed, so that because summary judgments are huge, they're massive undertaking that takes poor lowly associate
I've been
hours.
that person. Mm-hmm.
We've all been there. poor lowly associates hours and hours and hours to put together because there's multiple pieces to it. You have to put the evidence in place. You have to make sure that the evidence is supported, and it's a massive filing. And so anything that you can do to narrow the claims before you file a summary judgment is the best thing that you can do for yourself. So I think this was a very smart move for them to bring this. Usually, and I'm curious what your thoughts are on this, because I'm a client. So usually clients don't want to pay for this
Right.
because they're like, well, let's just try our hand at summary judgment. Why waste the time and energy to do an MJOP? But this is a massive case, and there's a lot of claims, and like trial is looming. So they made the cost benefit analysis that it's worth filing this motion before a summary judgment motion. What do you think?
I totally agree, because it is much cheaper. And like you've said, it preserves their arguments. I think one of the questions I've been asked a lot, and I think probably could use some explanation, is like, why is it so different from a motion for summary judgment? So motion for summary judgment, you're making similar arguments, like the law does not, this case does not need to go forward because the law doesn't allow it. But at the summary judgment stage, you get to bring in everything that you found in discovery. So you're arguing there's no genuine issue of fact for a jury to decide, which means that all of the facts start coming into focus. And of course, it gets incredibly complicated when you get to the facts. And I think that Wayfarer probably thought at the beginning that, we want that. We want the facts. We want to get into a fact battle with her. And so they didn't file a motion to dismiss. But all I can guess is that they've gotten to a point where it's like, all right, we've done enough of that. This is getting tiresome. We're fighting over everything. And you're right. It's getting really expensive. I don't know how many experts everybody has retained, but each side has got to have at least a couple.
Yeah, I sometimes I try to think about what the bills look like in this case, and I'm just like, it makes me sick.
Her money's green, like I've
Yeah.
had plenty of times where it's like, do I really listen? I'm like, well, they pay.
Yeah.
When I first started working as a lawyer, I worked for a guy. He was very grumpy and mean, but he was very good. He was a terrible boss. And he
I had one of
this, I learned a lot from him, but I also learned I don't want to work for someone like that. But he had a client that was like a property developer, and that guy was so litigious, and he wanted to file litigation over everything. And I remember being in like the third case I had to deal with him. And I remember saying to the lawyer, like, why do you keep doing this for him? And he's like, if he wants to pay for it, who am I to say no? I got kids I got to educate, right? Like, so...
Yeah.
I can't blame them for continuing to litigate a case where they're making money. I personally would not have put my name on a letter saying I get to go first because I'm the plaintiff, because I think that's embarrassing.
Yeah.
But that's me.
Yeah. I think there's always one, coming up as a litigator, the partners I worked with always said all it takes is one crazy client, one crazy opposing counsel, one crazy opposing side, one crazy judge that drives up the cost of litigation. And so it only really takes one to make something spiral into crazy expense. And a lot of it is client driven. If the client's like, here's an unlimited amount of funds, go do everything and anything to get this done, because there are things that have happened in this case that just would not have happened in a typical employment case. Like you just don't see that level of, let me go and subpoena YouTube to get like all of this data about random content. Like that's just not something that typically would come up, because you're not going to spend the money to do that. It's a waste of money to do that. And most companies are trying to preserve money. And so like here, they're like, unlimited funds, go crazy. And so this is like, honestly, they should teach an entire class in law school about like, these are all the things that you could do if you had unlimited funds.
It's true. I feel more and more, the more I see that the conversations that happened when Lively was hiring lawyers and figuring out what the strategy was going to be, that there must have been a lot of like, this doesn't fall into any particular category. we're going to have to make it up as we go, because as we have both said, and many others have said from the beginning, a smear campaign is not illegal all by itself, even if there were one.
Right.
And I think she said, I'll pay for it. I just want to find out who did this. And they're just like, okay.
Yeah,
So
that's what all the discovery points to. Like they're trying to figure out who was responsible for people coming on TikTok and posting badly about her. Who was responsible for the news articles that highlighted X, Y, and Z. That's all it seems like the discovery is fixated on. We haven't seen, and maybe there hasn't been disputes about it, but we haven't seen a lot of dispute over like, oh, employee X won't testify about what happened on the set of It Ends With Us, or oh, they won't hand over their previous records on whatever, whatever. Like we just don't see much on the hostile work environment claim. And so you're right. I think that she's like fixated on figuring out who did this. Let's like, get to the bottom of that using litigation to do it. It's crazy.
I mean, I guess there is, now that you say that, I guess there is another benefit if they could get, especially some of the discrimination claims kicked at this motion, is that those third-party witnesses who don't want to be a part of this, like Isabella Ferrer or Taylor Swift or whatever, they could say, you don't have to deal with this anymore. Right? I mean, there is that motivation. I think what Taylor Swift's lawyer has said in front of us is probably what all of these people and their lawyers are thinking, which is, if you make me, I'll comply with my civic duty, but I really don't want to, because who wants to get in the middle of this?
Yeah.
So I guess that could be another thing of like, hey, wouldn't it be nice if we didn't have to have, everybody who was in the room of the birthing scene give individual testimony about what they saw and what they heard? Because that gets real messy real fast.
Yeah. And I mean, I always think about like, what are other actors thinking? Like, what are other actors that are going into these types of scenarios, these types of shows, movies? Like, what is it impacting them in some way? Are they thinking like, oh man, I don't want to have to like, or is like, what is Hollywood's reaction to this? That now we're going to have to parse apart exactly how a scene is directed and like it. I think there's going to be ripple effects for Hollywood from this case because now everyone is like, am I gonna have to,
Right. This is weird. Well, a big thing for me to learn was remember when this first got filed and everybody was all worked up about the intimacy coordinator, and that was like the story of the day. And there was an intimacy, remember? And then they had like, they had somebody look at it and say there should have been an intimacy coordinator or whatever. And then great creators on here who are in the industry were sort of like, that's not what you guys think it is. And for my part, my limited knowledge, I went and looked at the SAG rules, and you are hardly ever, if ever, required to have an intimacy coordinator. It is a suggestion, but it is not a requirement. And I don't think that the movie industry at large wants it to be. Right. So I would think that sort of the Producers Guild and all those people would fight back.
Yeah, it's interesting because like while like I would support generally there to be better practices in work environments. I'm pro that. Like that's a good thing. But this seems to kind of like maybe make it more about litigation than it is about better work environments. Like don't do this because you don't want to get sued. And that
Right.
doesn't necessarily make a better work environment. Like this is not, that's not the outcome of this case. The outcome is now everyone is like tense and scared that you're going to come after each other. Like, is that the goal here?
That doesn't seem very good for creativity. Well, and the thing that I think people noticed early on, and that you and I have sort of confirmed, like that's actually part of the legal argument, is the power dynamic.
Yes.
Because sexual harassment has nothing to do with sex. It has everything to do with power and control. And I think that's really hard sometimes for the public at large to get, but it has nothing to do with sexual attraction or sexuality or any of that. It's about controlling somebody. And, we always assume, especially with what happened after Weinstein and all of that, that the people who were being accused had the power and they wielded that power in an illegal way. But what's always been so fascinating to me about this case is that she had more Hollywood power than he did.
Mm-hmm.
And so that to me is interesting in terms of like a bigger actor with a smaller director. I would think that if you were that kind of person, right? Like I'm making this small indie movie and I got lucky enough to have this incredible, Oscar nominated actress in my film, the power dynamic is off. And so maybe the whole thing doesn't work.
Yeah, I agree. I always, if you even roll back to like the formation of the EEOC, the intent of these laws, anti-discrimination laws, was to address the power dynamic between the one that's paying you and the one that's getting paid. That's why they exist, is because when you're sitting there like, I have to feed my family. So what, you get to do whatever you want to me. You get to touch my body, or you get to treat me differently on the basis of my, you know, category X, Y, Z, and I don't get to say anything because you feed me and my children and my family. So that's exactly why these laws are in place, because it's protecting the little guy from the big guy. The big guy being the one with the pocketbook, the one that's giving you a livelihood. And so in this situation, it's completely reversed. You have the person that has all of the power, and there's even like an illustration of that. She got the PGA credit, she got her picture on the poster, she got everything she wanted after she made her complaint, which goes to your point about the adverse action. We can talk about that. But she got everything that she wanted. She had the power. So even when she complained, she wasn't at risk of not being able to feed her family anymore, not being able to have her job anymore, because she got more than what she was given at the beginning. It's almost like getting a promotion after making your complaint. Like, and why was that? Because she had the power to do so. So to turn around and say like, I'm affected by this power dynamic, no, you had the power in the situation. So you're kind of like bastardizing the law. The law that says like we are protecting the powerless in this situation.
Yeah, and I think you would agree with me, but if you don't, it's okay. But the US, I know we have a lot of international people here. The US is a very employer friendly country in
Yeah,
general with our laws
very.
because of capitalism, right? So the US laws, California is a little bit more employee friendly because it's more progressive. But in general, federal laws in the United States favor the employers far more than the employees, because it's sort of like, well, if you want to work here, you're going to have to follow my rules. And so, they're going to have more rights to begin with already. But the fact that, like, I just keep looking at like the 17-point list meeting and then the all hands meeting they had in January. Y'all, I have seen CEOs and COOs of good-sized companies, and they can't get an all hands meeting just because somebody complained about harassment. Like, that is not a normal thing. It's
Yeah.
just not. You have to have a lot of authority to be able to do that. And that doesn't mean she can't be harassed, and that doesn't mean she can't be treated differently because she's a woman. But when it comes down to, could this actually meet the definition of being illegal harassment, it makes it a lot more complicated.
Yeah, no, it's totally true. Yeah. It is that way. I mean, California has really worked to become a more employee friendly state. And so I kind of scratched my head why they didn't just file this in California. Honestly, because even the judges are more favorable to employees than employers. And whenever a company gets sued, they're like, oh my God, not California. California is a difficult state to be an employer in. Um, but yeah, like generally the US is very friendly to employers.
Yeah, I do. I mean, I know why they picked New York, sort of, but you're right. I mean, I guess the production they had a venue problem, I guess,
Yeah.
right? Because all the witnesses and everything were going to be in New York.
Yeah, and that's the other thing. I'm like, they knew all of the conduct was in New York and New Jersey.
Mhm.
Like, how are they going to prove that nexus? Like, what is the nexus? I don't know that they pled that. I mean, I'm kind of trying to see where they wrote that in
Yeah,
this
you did a
motion.
preview of this when you were doing the 47.1 motion about can you apply this law outside of California? And it was like, well, that makes all the sense in the world. I mean, why should a resident of New York have to deal with a California law? They didn't elect California
Hmm.
legislatures. Oh, you're right, the New York Times stuff.
Oh, New York Times.
Remember, Wayfarer originally sued the New York Times in California.
Hmm.
Remember, that was their first case. And I think they would have been fine there because I guess there's a bureau there. And then they pulled it to New York.
Yeah, I'm trying to remember the order of events because they filed against New York Times first and all of the Lively defendants, including Reynolds and Sloan, etc. And then Blake filed her lawsuit in New York, and then Wayfair moved their stuff over to New York. They're like, okay, sure, like put it all together. I mean,
Put
it
it all.
benefited them to do that.
It did. And that is probably the question that I have gotten the most since the beginning is like, why is all this happening in New York? And I've tried to do, I know you have too, I've tried to do a couple videos, but like subject matter jurisdiction, personal jurisdiction, venue, like it takes you a very long time in law school and in practice to truly understand that. And it's not because it's complicated, it's just because you kind of have to
Hmm.
build. So don't feel bad about yourself if you don't understand that. But it's not one of
Yeah.
those things we can answer in 2 minutes. There's a lot to it.
There's a lot to it. And also, in a way, there's not a lot to it. It's like you kind of just get to a point where you're like, okay, it's going to be in this state or this venue, not necessarily the state. But you know, you have a choice sometimes, and it makes sense to do things one place versus another place. And then you're like, well, which one's more favorable? This one. And you just go with that one. And then that's it. And then there's like not really a smokescreen. It's just it is what it is. And in this case, the fact that they have it in New York, the only bad thing for Lively is that they're trying to get a New York federal judge to opine on 47.1, and that was never going to happen. It's not going to ever happen. And I don't even know that a California federal judge would have, but if a California federal judge may have certified it to the California Supreme Court, or I don't know, there may have been something else if it was in California, but I don't even think a California federal judge would have ruled on first impression on 47.1. So that's the only kind of bad thing that for Lively for doing that is they couldn't get those atrocious amounts of punitive damages.
Yeah. I agree with the comment I just saw that there was a big consideration for her that this be in federal court so it wouldn't be public.
Mm,
I think that that's true. And,
smart.
you know, sometimes that can really benefit your client because it's already a circus and you don't want to have a circus, but everybody forum shops. I mean,
Everybody forum shops.
that's part of being a lawyer is being like, what's the most advantageous place for us to be in litigation?
Also,
And
federal court is preferable for all litigants. It's more structured, it's more clean, it's more it's like the wild, I don't know. I mean, California courts are the Wild West. Like crazy things happen in the Superior Court. So I can't imagine. I mean, I mean, if anyone saw the Cardi B trial, that is an example of the Wild West.
that was awesome. That was absolutely awesome. I love. And then she's just gone on this media tour because she's doing an album anyway, and
Oh
everybody's
yeah.
just like, "You're delight." I mean, she couldn't have bought that publicity, honestly.
Yeah, well, she
Just,
did what, 7 years of defending that stupid case.
oh my god! Just so you guys know, like 50% of civil litigation is that kind of stuff.
Yeah.
It's like slip and fall, public liability. I tripped and fell walking out of a restaurant. I'm going to sue the restaurant. Like that's what a lot of civil litigation is. It's not always this interesting. And that guy clearly had not ever done anything before, ever. Bless his little heart. He didn't,
Bless his
that case for
heart.
7 years, he didn't depose her.
I cannot understand how he didn't depose. You're gonna go to trial. That's the craziest thing is you had a plaintiff that you're had every opportunity to depose Cardi B, and you didn't take the chance to do that. You just, on a hunch, thought that you could get a gotcha on the witness stand, and if anything, it was the other way around. She had him. She was turning that guy in circles.
I know. Well, and it's so funny. Like, I'm sure you get asked this too, but I get asked all the time. We need to do a recap on the motion because new people are coming in.
Yeah.
I get asked all the time, why do Lively's lawyers keep bringing this case if it doesn't have any, it's frivolous. This is not a frivolous case. You may think that she doesn't have what it takes to win it, but this is not a frivolous case. That was a frivolous case.
That was a frivolous case. Yeah.
There's zero evidence other than this woman's word. And that word is belied by video and multiple witnesses.
Do you remember where they showed the like picture of her cheek and they're like, so where is the scratch? She's like, here. And like you like look at it, you're like, but where?
She's like, she touched me. Oh my
No.
God. I'm pretty sure that if Cardi decided to throw down, she would throw down.
Oh yeah.
And she
in
would
so
get on
many
the
words
stand and be
almost
like,
said
you're
that.
damn right I did. Yeah.
You're like, yeah, I did.
All right, you want to do a recap of what got filed?
MJOP
just showed up.
Yeah, so it looks like our live was restricted for a bit. So hello to everyone. We're not doing anything nefarious, so apologies for those that were locked out of this. We just, we're two lawyers that couldn't really figure out how to use the live. And so our friend Katie here did us a solid and is hooking us up with this live. So welcome. And we're talking about everything about this Lively Wayfarer case, but really what prompted this is the big filing last night, which was Wayfarer's motion for judgment on the pleadings. And a MJOP is exactly like a motion to dismiss. The only difference is that when you can file it. Well, you can pretty much file it at any point, but once your deadline passes to file a motion to dismiss, which is usually just a few weeks after the complaint is filed, so it would have been due like in February, March, then you can't file a motion to dismiss anymore. You can file something called an MJOP. It's the same exact thing, same exact legal standard. It's just filed later. And there's various reasons why you would file it, earlier on in the case, in the middle of discovery or after discovery. And here we've been talking a little bit about what are some of the reasons why you might file an MJOP at this stage. And at this stage, discovery is about to end. September 30th is around the corner. That's when fact discovery ends. Never mind expert discovery. But fact discovery is ending. That means that the parties are preparing for motions for summary judgment. And motions for summary judgment is when the parties go, here's all the evidence, judge. There is no issue of fact because the evidence shows that we win on our arguments. And so they're preparing for that. And because there's 13 causes of action, they are trying to narrow those most likely before a motion for summary judgment so that they're only really litigating the claims that really could be where evidence would support the claims or defenses. So that's why they're probably filing that now. There's also an argument to be made that doing it now preserves these arguments for appeal because they're pure legal arguments. And this is also giving the judge an easy way to rule on the legal basis of the claims rather than having him weigh evidence because judges don't like doing that. So if it gives them an opportunity to get rid of claims based purely on law, the way he did against the Wayfarer parties in June, then he might do that now and help streamline the case as it goes into summary judgment and trial.
Yeah, that's another big benefit of federal court. Now, Wayfarer didn't choose this court, but one of the big benefits of federal court is that the judges have lifetime appointments. And that can be good and bad depending on the circumstances, right? It's hard to get a bad judge out of federal court. But because they are lifetime appointments and they don't have to worry about getting reelected or reappointed by a politician, they are unafraid. They just do what they do. Now, they don't want to get overturned by an appeals court, or they may have their eyes set on being on an appeals court or being on the U.S. Supreme Court, so they don't want to act crazy. But state court judges are usually, because they have to worry about keeping their jobs, typically are a lot less likely to bring the hammer down on somebody. But a federal court judge will do that, as you saw with Wayfarer's claims. He's like, sorry, we're not going any further with this. So I think that gives them a better chance. then they would
Yeah.
have this in state court.
Yeah, and also motions to dismiss are, I mean, he granted it, but they're typically disfavored.
They are.
And it could have been that Wayfair thought that and was like, we're not going to risk looking bad losing a motion to dismiss, and thought about the ramifications of what that has. Like, think, and anything that they lose becomes this big national, international headline. And so they made a calculation that if we were to file a motion to dismiss and it loses, that might look like we're, this big bad whatever. And so they thought, let's let discovery happen. Let's get all the facts out on the table. We mentioned this earlier, but for the benefit of the people joining now, let's let all the fact discovery happen. And they did. Minus 3 days, they've let all of discovery happen. There has been a lot. I can presume that there is a room the size of my office filled with banker boxes full of papers, like waiting for some sad associate to paralegal to go through.
100%.
Although it's not paper anymore, it's all online. But like, you still,
Yeah,
it's
discs,
that's the vibe.
That is. Yeah, I have seen so much that's happened in this case. Like when people get upset about the judge, and people have their right to complain about the judiciary for sure. He's certainly not perfect. Mickey, I know you're here to agitate, but like that comment doesn't make any sense. You would, if you've seen the facts are out there no matter whether it gets dismissed or not. If you want to ask a question, I'm happy to answer it. But a lot of what I've seen, like tried to look at through the lens of what the judge is looking at, is the judge is not looking at this as a case filed by Blake Lively, the actress, Ryan. He is looking at, this is a person who is claiming they were sexually harassed. And in his job as a member of the judiciary and trying to be fair and impartial, he is thinking, how do I treat someone who claims to be a victim of sexual harassment? Whether he thinks that person has a great case or whether he thinks that person has a shit case. And I think once you start looking at it through that lens, then everything he's doing, like, let's let her get as much information as she can get. If she feels unsafe, okay, I know we probably don't need it, but let's just let her have it. I think that's what he's doing, is he doesn't want to be called out for not giving a potential victim of sexual harassment what she needs to pursue a case, because that would make him look bad. I don't know if you agree with that, but that's kind of how I see it.
Yeah, I mean, and typically you want to give plaintiffs their day in court, right? Like, regardless of whether they're famous or not, judges want to give plaintiffs their day in court. And so they're not going, this is so distracting. There's literally a corgi's butt just came in
I liked it, but okay.
I liked it, but I'm like, wait, what was I even saying? That was cute. So, so they, judges want the plaintiff to have their day in court, and they're not going to be, and that's why motions to dismiss are disfavored, because they're like, yeah, but what if there's, something to be found in discovery? Now, there's that balanced with a judge wanting to streamline and clean up the stuff that he has to deal with. And so there's this balance that happens. And, I think that especially when you're dealing with a claim of sexual harassment, which is very factually driven, like you don't want to appear like you're preventing. And that's why a lot of people are confused about, why is Judge Lyman giving Blake everything she wants? Because she's alleging sexual harassment. You don't want to be the judge that doesn't allow discovery for you to figure out whether or not she was harassed. Now, I know a lot of the discovery has to do with this retaliatory smear campaign, but they're tied. And so, of course, the judge is going to allow as much discovery as possible so that he doesn't have to deal with an appeal one day that says he didn't even let the discovery on this X, Y, and Z issue. He's going to give them everything they possibly want to be like, okay, like, now let me see the evidence. And that's what summary judgment is for.
Yeah, and that's just a dynamic that's in employment cases a lot of the time, where if you represent the employer versus if you represent the employee, the judge or the investigator or whoever is always going to feel like they need to make sure that whoever is making the claim, because of the power dynamic. So I know that's weird for all of us because we know the facts of the case. But in Lyman's mind, this is a person who's claiming she was sexually harassed in the workplace, and I've got to treat her fairly, to your point, so that no one can ever accuse me of not giving her her due.
Yeah.
Um, and every once in a while, I'll look up the other cases that are on his. I'll go in Court Listener or Pacer and look up the other cases he's working on. And he is working on, well, his criminal cases, because remember, federal judges, you guys might not know this, federal judges do both civil and criminal, unlike state court
Which is
judges,
hard.
which is very hard.
That's a hard job.
It's a hard job for not all that much money. I mean, where
Yeah.
did he work before this? Like Wilmer? I don't know.
Yeah.
He was
Yeah.
making 7 figures a
He was
year.
making way more money doing that.
Yeah. Yeah. So this is a thing you do, like, okay, I want to be a federal, maybe he wants to move up. I think I mean, if it's kind of like they say in a mediation, like if you come out of a mediation or an attempt to settle a case and everybody's a little bit unhappy, then that's perfect. Right. And it's kind of like that with a case. Like if everybody wins some and everybody loses some, that's probably exactly right.
Yeah.
But this is going to be a big test because this is the first big dispositive. This is the first dispositive motion, period. This is the first really big motion Wayfarer's filed.
Yeah. This is their, I would say, their biggest play so far that we've seen, right? We don't know everything that's happened behind the scenes. We don't know what kind of deals they've struck with the other side. And I can guarantee that there has been, because like there are probably things that they're like, yeah, we can forego, doing X, Y, and Z, or, deposing your mom. Like, that's all like on the table. I've had situations where I've subpoenaed a plaintiff's husband or wife or
Oh, sure.
parent or whatever, best friend. I mean, it's totally fair game when you're saying like I'm emotionally distressed. Well, yeah, let's hear it from
Let's
your
talk
mom.
about it.
Like let's hear so I'm sure there has been plays that they've done behind the scenes in discovery that we just don't know about, but this is huge. And like to the extent that it gets reviewed by the judge thoroughly, which we assume he will, there will be a lot of narrowing of this case. This is a huge turning point for the case. I do not see a world where he just flat out declines to grant any of it, because some of it is just so logically sound that you can't really dispute it. So the opposition will be interesting.
Yeah, whenever I'm reading it, I'm always trying to figure out, like, what are they going to say? What's the response to this? Some of it I can see a response to this. But for those of you who just joined or missed it the first time, this is a dispositive motion, which means if Wayfarer wins in whole or in part, those claims are over. It is a judgment in their favor. They also might be able to get attorney's fees for some things if they get a judgment in their favor. But this is a motion that would take those claims out of the case for good. That's why this is such a big deal. Because if
Right.
Wayfarer were to win this, even, let's just say they got lucky and they won the whole thing, which is probably unlikely, all of those claims would totally go away. And the only thing that would be left are like a few breach of contract claims. And whatever culling happens through this, even if the judge takes one or two or four or whatever, you're then left with whatever's there. And then both sides reevaluate and decide, are we really going to go to trial on this? Are we really going to go forward on this? Can we come to some sort of a resolution? That kind of stuff.
Yeah, well, when the order comes out on this, narrowing the claims down to what they are, that will be an interesting conversation about like, is it worth their while to take this to a jury? And will a resolution be like, if let's say, the retaliation claims go away completely and I mean, are they just going to go to trial on, and a hostile work environment claim? Is it worth it to their PR to do that? I don't know. I'm not really the expert on that, but that's the analysis that they'll have to make once these claims get narrowed, and that will be really really interesting. As of now, a lot of people ask like, "Will they settle? Will they not?" Like that it really, at this type of case, it really gets to when we get to the summary judgment, when all the evidence is there and is presented, that's when you know when the real meat of your case is. Like that's when you know like what are your chances of surviving a trial or prevailing at trial. And so it's the analysis really comes in at that point, like, okay, like now we got to decide, is it worth it for us to go to trial? Most people it's money. Here it's going to be reputation.
Yeah. And the judge is going to require them, if they stay in the case, is going to require them to mediate at
Yeah.
some point, because all judges require that in all civil cases these days. Um, but like you just said, it's hard to mediate at the beginning if you're not sure what all the facts are. But once you
Hmm.
have all the facts in hand, that's when you can sit down and say, and when you have a settlement discussion, you literally talk to the other side about, like, listen, your best day is blah, 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 blah. And I think you have weaknesses here. And I think you have weaknesses here. So I'm going to make an offer to you. And that's going to be either better or close to what you would get on your best day, and it really just becomes numbers then. But you're right. With reputation, I don't know how they're going to do that. I don't
Yeah, I
know.
mean, that's the weird part about this case is like it is about reputation, right? Like that's everything
Yeah,
for these two parties. Otherwise, we wouldn't even get here.
that's true.
We wouldn't
I
even be
mean,
here.
she's not going to apologize. He's not going to apologize. And I just keep trying to think about the middle ground, right? Like, they each make a statement that clearly there were some misunderstandings and they both just agreed that, I don't know. I don't know. I don't know how that would
Yeah,
work.
I mean, I think a middle ground would be both sides. It would be something like, we've decided to let bygones be bygones. Like, like no one's really acknowledging that the other one did harm, and they're both coming and saying like we've decided to kumbaya and like let peace prevail and not and let this all be in the past. And honestly, that is the best outcome for them, I think, is if they were able to do that. And unfortunately ego comes in, but like, and I'm not a psychologist, but like, if they were able to get to that point where Lively says, you know what, I'm gonna like I feel like I can let this go, and Wayfarer says like we're gonna let this go, and there's some kind of like exoneration of this like you're this evil sexual predator type of vibe that is driving a lot of the response to this. Then yeah, they might be able to get to a resolution. But because I don't think it's about money. Like some people have speculated that what sparked this, and I don't know if it's true or not, but like, maybe they wanted the rights to the sequel, and maybe that could be offered up, like fine, go have the sequel, but come back and say like, I've thought about this and maybe I misinterpreted things.
Yeah.
Like, I don't know, I just don't see that happening at this point.
I mean, a lot of people have talked about, and this is where we really need the industry experts. Maybe we can poke at them to make some good content on this. Um, I guess if you're Baldoni, the individual, you'd be like, okay, I just want to make sure that I'm hireable, right? I want to make sure that there's nothing out there. Now, I know in Hollywood they have morals clauses and all these things you don't have in a regular job, but I just want to make sure that I can show everybody I was never found to have done anything wrong. But since he works for Wayfarer and they make all of their own content, I mean, maybe he also wants to be an actor in other projects. I don't understand fully how reputational harm for him as a director and a producer and somebody who is, putting things in development, how that is affected if, there's never a finding as to whether he did anything wrong or not. I get
Yeah.
why if it's like you sexually harass somebody, so you're never going to be able to work in Hollywood again, which, give me a break, of course he could. But I don't really understand that part.
I'm curious. I mean, to that point, to your point, like it would make it hard to settle. Like if you're Baldoni and you're like, no one's gonna come work on my sets still, because there's still a huge part of the population that thinks I'm a predator because you went and told everybody that I'm a predator through litigation. And I couldn't do anything about it because you did it through litigation. It's like
Right.
it's this weird kind of like loophole that is allegedly ruining his life. So I don't know that it would have to be something that really exonerates him from that for him to be like, okay, I'm willing to walk away from this too. But a lot of I've made a video about this, but a lot of people have asked, like, can she just drop her claims? No, she can't just drop her claims. She doesn't get to do that anymore. It's too far in. The procedures won't permit that. She has to get them to agree. And so if we see that happen, it's because they've all agreed behind the scenes in a confidential settlement agreement. But that's what we're talking about, is like, is that even possible for her to drop her claims? Because would they even agree to it? What would those terms be, you know?
Yeah.
Have we missed questions? I haven't been reading any of
Probably.
these.
I'm going to go back to something we talked about at the very beginning, which
Yeah.
was, in terms of, we're talking about settlement, but like, what did Wayfarer want? I think we agree that one of the things they really wanted to get out of this litigation is to get Blake Lively under oath in her deposition, which they can drop on us anytime they want to. And they got that. And so let's just say that they come up with some sort of resolution and it's wishy-washy and it's like, oh, we're all whatever. They could turn out the next day and just drop that deposition on the internet where, presumably if they would want to, it completely undermines all of her claims, right?
Mm-hmm.
So we don't know what other evidence is out there because, we haven't seen 95% of it. I do think that if I were a Wayfarer, there is no way I would agree to any kind of resolution unless I maintained the ability to share that information publicly whenever I felt it was appropriate. Because I think they also saw how well that did them, right? When they dropped the footage about the dancing scene, when they dropped the timeline, they seem to feel, at least up to this point, that giving us the information helps them. So even if they did have a settlement, I can't see them giving up their right to do that.
That's a good point. And the confidentiality drops when, because the protective order is only up until trial, right? So that unless things get filed under seal, they'd have to file her deposition under seal for it to be sealed away forever from the public. And they might be able to do that for parts of the deposition that have like personal identifying information, yada, yada, but they won't be able to seal the whole deposition. Like,
No.
I've never seen that.
I mean, many people have said people who work with like abuse survivors can't get their depositions sealed.
Yeah.
I mean, I've seen some pretty bad shit in my life and none of it was sealed. Unless it's dealing with children, it's pretty tough to do. We're getting a lot of questions about Van Zandt. Want to talk about Van Zandt?
Van Zandt. Where do we start?
So this deposition is supposed to be of the corporate rep, and we don't know who that is.
It has to be Ryan, right? Like I can't imagine it being anyone else. I've thought about this a lot.
It has to be. Does that company, I know that Elsie or somebody had pulled up all the corporate records for it. It's like him, their manager, and then like a registered agent, right? It has to be Ryan.
Yeah. It has to be Ryan. I mean, you can't have the process server registered agent be the designee. That doesn't really make sense. They're not in the corporation. So, and there's no one else named. I think she's a member, if I remember correctly, and I can't easily find that whenever I want to look for it. It's such a
I'm
pain.
trying to find it now.
But he was, so I do remember in June, around the time that Wayfarer moved to compel the Van Zandt docs, that they filed an amendment and made Ryan the CEO. And that's interesting. And I remember scratching my head like, why did they do that? And I haven't gone around to make a video about this, but I think there's something about spousal privilege that they wanted to get around. So when they brought up that they're not willing to bring someone to talk about something before September, the filing of the lawsuit, it made me think like, well, what happened during that time frame? If Blake was the owner of this organization, then presumably she was the one that was having, she would be the corporate representative. Making Ryan the CEO makes him the corporate representative. And so now you have this issue where he's going to get deposed about communications that he had on behalf of Van Zandt about filing this lawsuit, this Doe lawsuit. And so those communications are going to include, did you talk to Blake Lively? Not your wife, you corporation, Van Zandt. Did you talk to Blake Lively about this? And I want to see all the communications about it. Totally fair game.
Yep.
Totally fair game. Let's say it was different. Let's say it was, whatever. I always look at like what's on my desk and then name the thing. Stanley. What if it was like, what if it was Stanley? Stanley, Corporation Stanley, did you have conversations with Blake Lively about this lawsuit that you filed against her, movie set? And so, yeah, you bet your bottom dollar there were conversations between Ryan Reynolds and Blake Lively when they were going to file this Doe lawsuit. And so then there's the question of, is that privilege? They're married. Does spousal privilege attach? And it's like there might be answers to that, but that just makes it really hairy. Imagine sitting in that deposition, you're going to object like crazy every time a question is asked about what kind of conversation you had, because you're going to have to parse in your brain. Are you answering as Ryan Reynolds, the husband, or are you answering as Van Zandt Corporation?
Yeah.
Because if you're answering as Van Zandt Corporation, you don't have no spousal privilege. I don't know why I just got like, crazy talk, but like that's you. So that's the question I think that is going to come up, and the problem that has been created here for Wayfarer by naming him as the CEO of Van Zandt.
Yeah, I agree. Lots of spousal privilege questions. I mean, it's more complicated when a husband and wife also own a business together, because as you were just saying, the point of the spousal privilege is that you should be able to talk to your spouse without that person then being compelled to testify, right? Everyone should have a safe space. But when your spouse also becomes your business partner, then you have to kind of figure out, was this a business partner conversation or was this a spousal conversation? And it applies the same way in civil as it does in criminal. Someone just asked. The evidence code is the same regardless of what type of court you're in. It doesn't change. But honestly, I mean, I've been thinking for a while too, like you said earlier with her sexual harassment claims, and even to some degree her retaliation claims, some of her damages are her emotional distress. And she's like, this hurt my family. This hurt my day-to-day life. Well, Ryan's got to testify to that, doesn't he? He's there.
Yeah.
So,
Yeah.
she might have had to waive that privilege a little bit already, just so that, I mean, if they want him to get on the stand and say, I lived with this woman and she was miserable, which it sounds like they're going to need because they don't have the medical record for it.
Didn't she lose her emotional distress? So she don't they have to, now, didn't she go with garden variety emotional distress by waiving it, basically?
She did.
So
Yeah.
that means that she can't have anyone testify on her behalf. She just is what's her word against, Wayfarers, right?
I mean, I guess if there was like a nanny or a housekeeper or her sister or something.
Yeah, but to your point, yeah, I mean, he would be the one to testify on her behalf about her emotional state. And that's when you would waive spousal privilege to be able to do that. But I don't even think you get to do that when you're coming in as not Ryan Reynolds. You're coming in as the CEO of Van Zandt.
Yeah.
Like even let's say somehow they have somebody else appear to testify on behalf of Van Zandt. It's some other person, whatever. They go hire someone tomorrow and educate them on everything. Those communications are still relevant. And like I can imagine that there would be an issue because if they're talking as a corporation, Van Zandt, who went and filed this Doe lawsuit, then all of that is relevant to the claims. And the judge essentially even ruled that even communications with the lawyers are relevant and are discoverable here. So there's a lot there that's coming out that we unfortunately don't get to see.
Yeah. A lawyer cannot be deposed as a corporate representative of a company because every single thing that they say would be covered by attorney-client privilege. A lawyer is not a member of the company. It's going to have to be somebody who makes the decisions. And it may be narrow. The thing that I'm the most interested in, I did a video about it the other day, is that the Van Zandt lawsuit is specifically based on the idea, it's a breach of contract case, that Van Zandt is suing Does 1 through 10 for breach of contract. Yet they claim, so they're like, we have a contract with you and it requires you to do this, but we don't know who you are and we don't have the contract. I would love to ask those questions, right?
Oh
Because
my
it's
God.
like, you're going to bring a lawsuit against somebody based on breach of contract, but you don't know anything about a contract. I think they know what the
But you don't
answers
know
are.
who you were in contract with.
Come on. Come on.
Come on.
And I think if the answer is, well, you know, it was unclear, then that allows Wayfarer to say this was a sham. I think they're trying to establish that this was, in fact, a sham. What that'll mean, we still have yet to see.
Yeah, that's a question that comes up a lot, and I don't have a good answer ever for it. It's like, well, what are the ramifications for this? And I think I hate to use the lawyer response. It depends, but I think it just depends on how Wayfair decides to use it. Like, it's not quite criminal law where, there's a fruit of the poisonous tree argument where evidence could be excluded. But, I could see it coming up in a motion in limine before trial to say, like, this evidence, there's unclean hands and what have you. Some arguments to be made that we can't present certain types of evidence because of whatever. I don't think that that's likely to prevail. But I think, they could seek an abusive process claim against Van Zandt and anyone associated with it. There are a few options for them. I don't know exactly how they will go about it, but it's not a good look for Lively and her side to have this like looming over them.
Yeah, I mean, it's not, you can use evidence that you get from a different case, in any case that you want to from a civil standpoint. Evidence is evidence. But this took it so far beyond that. And I think people have largely stopped. But I got so tired for a while of people litigating in the comments this issue of, but did Stephanie Jones own the phone or did Jennifer Abel own the phone? Whose phone was it? Was it her work phone? And it does not matter. The point, it might matter for Jen Abel's claims, but for Wayfarer, it does not matter what device it was on. What matters is that there were communications that Jones had custody of that Jones agreed to keep confidential in writing, and she didn't do it.
She didn't do it.
And so it doesn't really matter whose phone it was.
Yeah.
And I think all of us feel, it's interesting, like from a PR standpoint, that gets some play, but I think it's hard for people to understand who are not in this case every day, like everyone here is. Like, I would like to see an article written that truly explains, maybe if we ever get the facts, that like they used this company that had nothing to do with this, filed a case that they knew had no merit, use that to get a subpoena to somebody to get documents that were confidential that they weren't entitled to, and then use those documents to write a New York Times article and file a lawsuit. Like when you put it all together logistically, then it really, you see how bad it is.
Yeah.
To me.
Yeah, there's one article I remember, and it was like maybe it was a blog post. I have to go back and look. There's one that did a good job illustrating this. But the other day, I went on Google and I searched Van Zandt and I clicked news like on Google just to see like what the recent articles are about Van Zandt. And there was nothing since April. There was no coverage about Van Zandt that I could find like readily available to me about Van Zandt. No one's talking about it, which is bizarre to me. And I don't know if it's just because there has been a way to like push articles down, like SEO manipulation. I don't know, but this is just not something that mainstream media is like really delving into. It just is very suspicious to me. I don't understand it at all.
I mean, I had those videos muted, and then I saw a creator the other day. She doesn't talk about this case all the time, but I got fed her video, and she's like, I did a thing about that subpoena, and hers got muted too.
Yeah, mine got muted too. Yep.
Yeah. So, I think Wayfarer has to figure out how to like present it as a motion or something. But, it is, I guess everybody's entitled to their belief about like what's smart lawyering and what's shady. But I mean, all of the people who say, like, it's fine, it's really not that big of a deal, I think it's really important about what would you feel like if it was you? What would you feel like if information that you gave to a therapist or your gym or your employer or whoever, that they told you, don't worry, this is going to be kept confidential, and then you found out that someone subpoenaed them for it and they didn't even tell you and they just handed it over? I don't think you'd think it was really smart lawyering then. I think you'd think it was shady.
Yeah, someone who was
But
protecting that was required to protect your information contractually was like, actually, I'm just gonna hand it over. Like,
oh
what?
no, it's fine.
No.
Well, and what was it? You said it the other night about one of the things that got filed, and they said they got like 8,000 pages or something from Jones. And it's like, that means it must have been her entire phone,
Yeah. Yeah. I'm like
including her
8,000
personal.
pages associated with a lawsuit that was what on the docket for 5 seconds. Like, how are there that many documents? What were the documents?
Is that like
And like,
her nail appointments? Like, is that everything?
I mean, right? Like it begs the question. I mean, either they're exaggerating that number, which they've done kind of in the past, presented information that seemed outrageous, or it is really that many documents, and you're thinking like, well, what does it contain? How is there that much communication or email traffic, text traffic about a lawsuit that was against a Doe defendant that didn't go anywhere, that was withdrawn before a judge was even assigned to it? I don't know. Yeah.
Yeah, and then published them in the New York Times.
Yeah.
It's all, I feel like when the history is written about this, there's a couple things that are going to stick out. And one of them is going to be, you know, the way that those emails made everything look in the New York Times. Was it what it appeared to be? And is there actual evidence that those things was done, or was that just posturing? That's one of the things that kind of looms over this case. I will tell you one thing I have learned is that all of the people on the Wayfarer side, be it Friedman, Melissa Nathan, all those people, they need to get a lot more deliberate and intentional about the shit that they say in writing and who they put on text chains. Because, you know, they are having to fight about these signal messages, maybe being privileged, maybe not, because they've added everybody and their sister to these messages. And
Yeah.
I'm sure you've had this situation too, where, you know, you have clients and they're like, okay, well, let me get the security guy. I'm going to add the security guy in here. Okay, well, I'm going to add the HR person in here. Okay. And then you're like, you guys, if you add too many people, we're going to lose the privilege of this conversation. And it seems like they got really loose. And it seems like Melissa Nathan and Jen Abel, when Jen Abel was moving over at this critical time, they got really loose with the stuff that they put in their text messages. And it's kind of law 101. Don't put it in writing if you don't want to see it on the front page of the paper.
Yeah. Say E for email and E for text is for evidence. I always tell people that when I give harassment trainings, like
That's awesome. I love that.
you, and like there's this exercise I always, when I used to give trainings, I don't give them anymore, but when you read a sentence, you can, if there's like 10 words in a sentence and you read it 10 times, emphasizing the first word, then the second word, then the third word, it has 10 completely different meanings. And they're always going to pick the worst meaning. They're going to bold, underline, italicize the worst possible meaning. So don't put it in text. But also, like sarcasm and context and inside jokes, that stuff gets lost. So you're just
It
saying
does.
like, oh, you blah 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 blah, that's how you really feel. Like that's why it's really just bad practice. And I agree. I mean, I get emails sometimes, clients adding all these people in, and I'm like, no, well, I'm not going to advise on this because like this is not, they're just going to go produce it. And the worst thing you could do is have your lawyer be a witness. Like, you just don't.
That's bad.
I
You
want to talk
don't,
about,
yeah.
I don't know if you have time, but I want to talk about the New York Times, trying to get their final judgment.
Oh, yeah, yeah,
Um,
yeah.
I want to know your thoughts about that.
I can't decide if they are doing that because they just don't want to think about it anymore, or if they know that something is coming. I could see the New York Times. Somebody made a really good point that like maybe they just want to report on this case again and they don't feel like they can while they're in it. That's kind of a point, although they're usually
Didn't they
not
already
scared.
do that? I feel like they did
Yeah,
report on it again.
maybe they did. Um, if you take them at their word, it's like we just want to be done with this so we can have the 30-day appeal period run and know if this case is over for us or not. I guess that's fair, but it still seems like there might be something else. What do you think?
I I think that, well, one I don't know. I feel like they think something is coming because why now? Like they could have done it months ago. June 9th was the order. They could have come on June 12th and been like, okay, final judgment.
Why
Like, why
now?
now?
Yes.
Katie.
Thank you, Katie.
Thank you, Katie. Like that's the thing, and I wish I knew the answer or what the possibility. I'm trying to put myself in New York Times position to be like, well, why would I do it now? And with the limited information I have, the only thing I can think of is like I'm worried that something's going to happen with that order. And if something happens with that order, then I don't have that order anymore. And it's not final for me. I'm going to be dragged right back in. And so I don't know exactly how something could happen to that order. Is there new evidence that's going to come forward? Like it's very rare for an order to be amended or changed,
Very.
but it can happen. Crazier things have happened, even in this case. And so that's the only thing that I can think of is that they want to get out as fast as they can because the Wayfarer parties didn't stipulate to it. So if
Right.
the Wayfarer parties were like, okay, well, yeah, you're done. I mean, there's nothing to do here. Like, we'll go appeal and we have these appellate lawyers and they'll handle it, then fine. But they didn't agree. So if they didn't agree,
Yeah.
that means that there's something there.
Right. No, that's totally true. And I mean, the thing that makes the most sense with us being in the dark about most of what's going on back there from the things that we know is it could have to do again with Van Zandt, right? Like what if in the Van Zandt paperwork, discovery that got turned over, what if there's information in there that the New York Times advised them to go file a case and get this through subpoena? Maybe not the details of it, but that it was the New
Ooh.
York Times who said, we can't print this. This is not my idea. Some wonderful followers thought of it. That, we can't print this unless you can say you got this stuff through a subpoena, because while they could print stolen stuff, newspapers have done it before. In a case like this, I don't think that the risk would be worth it. It's not the Pentagon Papers or something. So what if the New York Times is all wrapped up in Van Zandt? And they're
Yeah,
like,
I
we just
mean,
want to be out so that nobody can say anything about us.
all it takes is one communication that involves New York Times and Van Zandt, and it unravels that, right? Like something that says, how did you obtain this? And they're like, oh, well, we're gonna, get it through a subpoena or whatever that shows that they're gonna like clean it through this litigation process. And then New York Times is like, great, go do that, and then we'll print. Because they've been working on it for months, right? The timing kind of lines up. They've been working on it for months, but they couldn't say through legal process unless it was through legal process. And so that
Right.
that that makes sense to me that there might be something that just makes them look bad. And look, like I'm not in favor of like taking the New York Times down necessarily. Like I think there's other free speech is being threatened heavily in the country at the moment. But
Is
so
that
but I think like this is not a good look for them. And so they want to get out of it as fast as possible.
But I mean, even if there were, I'm trying to think of the theory they could even be brought back in on because they have fair report privilege. I guess if they were advising them about how to get the documents, that's outside of the fair report privilege or something. I don't know. I don't understand media law all that well. And I know that people, like, I've seen a bunch of comments, and I know that people are mad at the New York Times about all of this. And I get it. And you're entitled to have whatever feelings you want. no mainstream media is 100% trustworthy anymore. But, at the same time, they're getting a case filed against them by, Justin Baldoni, who you might think is justified. They're getting a $5 bajillion case from Trump. And, even though you might see them as different, in terms of the merits being different, the laws that apply to whether they can be liable for those things are the same. And so it's like you kind of sometimes have to deal with, they might get out of a case you'd rather them be in so that they don't get stuck in a case that they shouldn't be in. But it can't be a coincidence that discovery is about to close and they find this thing.
No, there's something there. And my hunch is like, when like there's friend group drama and you're sitting there trying to like replay why is there drama? And you're like, well, was it this thing? Was it that thing? And you start to piece together these small things and you're like, oh, I never thought that this would lead to that. Like I never
Right.
thought this tiny comment I made on this other like over here was gonna lead to them like icing me out for life. Like it happens. Like we're humans
It
and
does.
things snowball and things go on top of each other. And I have a sense that a lot of this, everyone was like, wait, why are we here?
Yeah.
Like, shoot, maybe I shouldn't have said it that way. And now we're here. And now we're having to go back in time and explain why these little things happen in that because nobody anticipated that we were going to get to this type of litigation, this type of exposure, this type of risk. So like the New York Times was like, okay, just like go get it legally and we'll go print it. And then like this career will be over and then, we'll move on to the next hot story. Nobody like maybe
Right.
thought that there would be this massive lawsuit that they'd have to deal with. And sleuths that find everything faster than even the lawyers.
So I keep thinking about whatever in-house counsel they have at the New York Times, and they have a pretty big legal department. Whatever in-house lawyer was called that day to say, hey, we're going to report, because this is what they do all day long, right? Can we print this? Can we talk to this person? Are we going to get sued for this? And some in-house lawyer had to tell them like, all right, if you can get them to get it from a subpoena and we can say it's from a subpoena, then we can go ahead and print it. Somebody had to sign off on that probably. Now, Megan Twohey is a pretty big deal, and they probably give her a lot more room than they would give to other people. But they get a lot of protection because they're the media, and I don't think that means that people can't be upset with they feel like they were only given half the story, right? That they printed something that didn't really tell the whole case. I'm just not sure that's a legal problem. I think that might be a journalistic media standards problem
Yeah.
more so than a legal problem.
Yeah.
A lot of people are asking, could Megan be deposed? Probably not, because it would be
Yeah.
source information, and that's
Yeah, I don't think so. Unless they reopen that can of worms, which I don't think he'll reopen the can of worms. But I think Van Zandt is an issue for New York Times, and they knew, and that the timing lines up with the filings that came out. So we'll see. Some people have asked when these things are going to get ruled on. I think the judge is going to prioritize the things that need to be dealt with first. Like discovery is ending. He needs to rule on anything that relates to discovery first because the deadline is coming up. And then like stuff that he can resolve before stuff that he needs to resolve before summary judgment, this MJOP he needs to rule on before summary judgment is filed. It's possible that he doesn't. Believe me, I almost went to trial once and a summary judgment wasn't ruled on. It was like a week before that the judge ruled on the summary judgment. So it's possible because the timing sucks. But he's going to prioritize it over other things, certainly over fee motion, sanctions motion. That stuff's going to get kicked all the way to the bottom of the list. But in terms of timing, I think we'll see an MJOP ruling possibly even before this New York Times trying to seek final judgment, unless he's working on it, unless he's ready to go or his clerks are ready to go. I mean, I feel bad for those clerks.
I do too.
Like,
but they're all going to get great jobs, so they'll be fine.
they'll get great jobs.
If you get a federal clerkship, that's like really prestigious, and you can pretty much write your ticket into like any white shoe law firm that you want to. And
True.
A lot of them go and they get jobs as like second and third year attorneys making 200 plus. So they're okay. They're okay.
They're okay.
They're going to be fine. People ask a lot, like, could Baldoni file something afterwards? Could he, sort of sue for what he had to go through? And the answer is probably not. But I do think it's important for people to know that to the extent that Wayfarer prevails on this motion for judgment on the pleadings, because it is a dispositive motion, if they were the prevailing party on some of these claims, that could entitle them to have all their attorney's fees paid. And that is almost as good as winning a lawsuit, right? Because you basically get to pay back whoever's paying the bills. And you have to force the other side to go through that whole process. So that could be pretty satisfying. I don't think they want to get into another lawsuit. My guess is they would like, when this is over,
To be done.
for this to be.
Yeah, and fights will
Yeah.
be had over fees. Like they're gonna come and say
Oh,
we're entitled to $200 million, and then that's always a fight, and that's actually a time when you'll see settlement, is that the parties
right.
might like agree, okay, when we won't pay you guys pay your fees, we pay our fees, and then they walk away from something. But yeah, their fights will be had over fees for sure.
Yes, there will. And like you said, that would be a whole proceeding in and of itself. I mean, I've seen attorney's fees parts of the case that go on longer than the case
Hmm.
because, you can't just say, here's all our bills, pay them. They have to say that the fees are reasonable. Some of the people in this case are charging more than $1,000 an hour for sure.
Yeah, I mean, I
Um,
think Wilkie Farr and Manette Phelps both on Lively's side, two massive law firms where the associate rate is $1,000 an hour. The associate rate. So the partner rates are going to be way, way higher, especially if they're high profile like Gottlieb is. It's astronomical, the fees that are involved in this case. And judges are reluctant to hand over huge, huge fee awards. So that's going to be interesting. Somebody asked about the fees. There was some weird like tension or whatever in comments about the Van Zandt order and the court saying you can go file for fees. Like they were making kind of hay out of it. And
right.
it's a so what for me. I was curious what your thoughts are, but it's like, what are the fees associated with opposing that motion to compel? Like a couple $1,000s max? Like, are they even going to file it's going to be more expensive to file a motion for those fees than like, who cares? Like,
Right. You
it's
could
not a
just,
big deal.
they just It was like a page and a half letter. I think it was the judge just saying, like, no, and I'm pissed, don't come to me with stuff unless you fully conferred. I agree with you. I don't think it would be worth it. I think you're totally right that it would charge more. It would charge more to write the motion for fees than it took to write that letter. I
Yeah.
mean, when you see these letter motions, like everybody does it differently. Some lawyers, the old school people, they dictate. Were you taught how to dictate, or are you too young for that?
No, I didn't
Into a
dictate.
microphone? I was taught to dictate into a microphone. So you would dictate into like a little tape, and you would say like, okay, paragraph 1, blah 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 blah, and then you would, My son is saying that's a bad word, and then you would. And then you would take that tape and give it to your assistant who would then type it out for you. But nowadays, I mean, lawyers are just going to sit at their computer and be like, okay, somebody give me 45 minutes. And you just
Type, 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 type. Yep.
bang out whatever the letter is and somebody files it. It's not that
Yeah. I
hard.
never
Like
understood
Lewis lit
dictating.
his microphone. Yes,
Yes,
exactly.
Lois lit and his microphone. I can't, even though we talk online all the time, I literally sit there and I just stare out the window. My best friend has watched me make a video. I literally will say like one sentence and then I pause and I like stare outside. I'm like, okay, what's my next sentence? And people are always like, why you talk slow, slow? I'm like, I'm literally thinking about what I'm saying. And then there's no way I could write an entire motion dictation. That'd drive me crazy.
It's weird. But it's funny. You get used to it. I couldn't do something long, right? I always hated
Yeah.
doing some. I knew guys that would write appellate briefs that way.
Oh,
And I'm like, they have like 5 tapes. And I'm like, how? I would forget what I
yeah.
said. But when it's something really fast, people were asking if this motion gets granted, what happens to Jed Wallace? That would be totally separate for Jed
Hmm.
Wallace, right? I'm not missing anything, am I? Because these claims are not against him.
Right. These claims are not against him, so he would not be involved. Um, how does it impact his case? I don't know. I haven't even thought about that. There might be some
He's
impact
waiting
on his
on the
case.
updated motion to dismiss for personal jurisdiction, which I think he's going to get.
Yeah, I think he's going to get that too, which means he'll be out anyways. Did you see
Or
that
he'll
he's,
Texas.
yeah, yeah, that's right. Did you see that he's going to get deposed?
Yes, finally,
Yeah.
apparently.
And I don't know what that was about, but that made like the question about whether he could designate someone, I was like, I don't never heard of that. To designate
Never.
someone outside of yourself, like that doesn't work. You can't just like hire a contractor to show up for your deposition. That would be wild.
Wouldn't, if only you could do that, right? I
If
mean, the whole
only.
purpose of a deposition is that the person has personal knowledge
Yeah.
of the things that happened. He remains
Yeah.
very elusive to me. I still think I'm, there are people who are like free Jed. I'm like, I think Jed is probably behind some stuff. Maybe not in this case, but in other cases that is not so great. But I have yet to see an implementation here, only a plan. But there's a reason you can't find that guy's picture on the internet. There's a reason.
Yeah,
Because,
exactly.
right? He likes it that way. So I think that the fact that he's been pulled into this has really pissed him off. I'm sure it pisses him off that we all know what his name is.
Yeah, and who his clients are
Uh,
and what his text messages say. Yeah.
yeah, it's not great. Yeah, his lawyer is kind of the best though. I love his little funnies and his documents, and he makes us all giggle, and I love one of those Texas guys with the 10-gallon hats.
Well, this has been fun. And
This has been fun. I'm going to have to go help my kid with his homework here in about the next 5 minutes.
we
Okay.
end on a fun note.
If there are questions that you guys have missed, I can send you. I think I figured out the settings. It should send you a live recording of this whole thing after it's concluded.
Thank you, Katie.
Are you
for,
okay?
Like, yeah.
Yeah.
Oh, I'm good. Oh yeah, I'm fine. People are in,
Okay.
but other than that, no, yeah, we're good. We're just keeping on. Here, I guess I can untape. I taped a piece of white tape to my phone. Because I was like trying to figure out how to do this while remaining, because it's not my live, it's you guys. So I taped a piece of white tape so that background could stay on. But no, yeah, things are good. Everything's golden over
You're
here.
our handler. You're handling it. You're our handler. We need
You just
handling.
gotta. I don't understand it. You just gotta move on and just move on.
You know
to,
what
yeah.
happened? I tried to start a live and then it gave me a notification. It's like, you haven't done even one live on your own. So you have no permission to add someone. And I was like, oh, well, the
So
hell?
what you're going to have
And
to
so-
do is figure out your settings, because both of you will have to do additional lives, and then and I think it's a certain period of time, like 10, like it's a length. So even if you go live and then just leave it on mute or something, I don't know, maybe do it late at night and nobody knows or whatever, but I think there's a certain number of time that amount of time that you have to be live for before it'll allow you to get some of these people.
Yeah.
So
Yeah, well, thanks for saving us. Because then what happened was I exited the live, but my app still thought I was in the live. So it wouldn't let me join Nags live. I couldn't join it. So I was like, what am I supposed I literally turned my phone off and turned it on again. So thanks for saving us. That was great. We should have
Well,
is there like a fun
Katie,
question we
someone
could end
put
on?
Katie is our Chris
man,
Jenner.
I don't know.
True.
I'm over here.
You're our
I've
Chris
got my
Jenner. You're our
ghost blankie
monitor.
on. I got my skeleton. I told my husband, I was like, I don't know what's going on. I just literally, my kids were screaming because they needed naps, and I just stuck my phone literally in the mugs cabinet, like where my cups and things are. I was like, I don't know what to do with this. Here, you're just gonna go in my cabinet for a minute, and yeah, but I don't know what fun questions. I think you guys covered quite a bit. So thank you for, honestly, this has been so educational. You guys are both very, very knowledgeable people, and I love learning from you. So thank you.
Thank you.
Thanks for being our momager. We appreciate it.
Yeah.
We're trying to figure out how we can do more stuff together, how we can, do stuff that's more fun, that isn't just repetitive.
No, I get you. Well, and I think things Sorry,
Go
go
ahead.
ahead. No, you finish your
No,
thought.
I
I
was just
apologize.
fine.
I don't mean to interrupt. I'm not a good host. I'm an interjector, and I need to do better at being an active listener.
You're great.
It's
I think we
hard
were
when you're like,
just
but I have something.
we're trying to figure out how to bring more content to you guys, like not necessarily just lively content, but like some we're working behind the scenes on some potential stuff. So one day we'll figure out how to do a live on our own. Maybe we should master that. Step one.
Do individual lives
Shouldn't. Maybe we
separate,
should just-
and then or just have one of you tackle the individual live thing for a minute. But yeah,
That's true. Yeah.
I think
Well,
you just have
thank
to be
you.
your
I
own
remember when I was a young lawyer. I don't know if this is going to be like the dictation dates me, but when I was a young lawyer, I remember like the older partners in the law firm, like they couldn't make copies. Someone would have to go into the copy room with them and be like, okay, Jim, here's how you make a copy, because they were raised in the time that was like, my job is to be brilliant. My job is not to do technology. And I really am jealous because that was never the case for me. I was assumed, right? I'm sure you were too, like, oh, you will be a lawyer, but you will also understand all of the office things, all of the technology, all of the administrative things. So now I feel like we can just say, you know what, we're going to stop doing that. And we're just going to have Katie do it.
Oh, I like that. I want to be
Katie's our facilitator.
Older lawyer that's like, I don't do this.
I will host you guys anytime,
Don't do
and I'm
that.
going to do some research on how to get rid of these boxes because it drove me nuts the whole time. I'm like, there are 6 boxes on here. How do I get rid of them? I clicked every button I could I didn't want to interrupt you guys, but I think the only other thing would be to make you bigger, and I'll figure it out. But it drove me insane. I was like, because the whole time people would pop up in them like, invite me. And I'm like, no, please don't join anybody else in here. So I'm like trying not to touch my phone. I taped a piece of white thing over I'm like, how do I do this and stay as quiet as possible? So
Thanks.
yeah, thanks guys for everything and for spending time. And yeah, I don't know. Well, hopefully it'll send you the stuff. If you don't receive it, just let me know and I'll get it to you. So the appeal went through, by the way, midway. I don't know what was going on with that, but apparently
You were
somebody
able to
reported
appeal
that.
it midway? That's crazy.
Yeah, it said restricted, and I sent you guys screenshots of what I was seeing, but somebody reported the live and I was able to appeal it, but it wasn't searchable, I think was the only glitch with it. So yeah, pretty cool.
Yeah, if we get the recording and if my friend here agrees, I can post it on my YouTube if there's people who want to see it.
People will definitely want to watch that.
Cool.
So we can talk about that behind the scenes. But yeah, if I don't get it, I'll reach out to you, Katie, and we'll see if
Sounds
we can
good.
figure it out.
All right.
Thank
I don't
you
know.
so
you want me to
much.
hit the button and X's out? How do you want me to? Yeah. Sayonara,
You can X's
everybody.
out.
Have a good day.
Bye.